Good morning. It is Monday, October 20th, and every so often I do a consultation with somebody who doesn't realize that they are 245I eligible. In other words, they're eligible for adjustment of status under 245I, and they originally thought that they were going to have to do a family petition with an I-601A waiver. Most people know that if you had a petition filed for you prior to 2001, even if that petition was, not continued or it was denied, if it was filed in good faith and you haven't left the country, that you can still use those protections for adjustment of status, even if you entered the country without a visa. However, there is also the possibility of being grandfathered in under 245I. In other words, you might have been a derivative beneficiary on an application, and your parent had a qualifying filing. And this really comes up often in the case of labor certifications, that people don't realize that they might have 245I protection. So if somebody petitioned for your parent, oftentimes it's the father, or did a labor certification, applied for a labor certification. That's all you need is proof of the application, and you were under 21 and unmarried at the time, you also are highly likely eligible to adjust status under 245I. Now, you had to have been listed as a derivative, and there are a couple physical presence requirements here. So you must have been physically present in the U.S. in December of 2000 if your petition was filed between January 98 and April 2001, April 30th, 2001. However, if the petition was filed prior to January 1998, then that physical presence requirement isn't even a requirement. So you do not need to prove that you've been physically present here since 2000 if you were under 21, unmarried, and somebody did a labor certification for one of your parents prior to January 15th, 1998. Again, nothing had to have come of it. They didn't have to proceed. It just needed to have been, approvable when filed, meaning it wasn't, fake or clearly ineligible. Whether or not it was denied, whether they proceeded, irrelevant. So if you are in the United States, you're thinking you need to do an I-601A waiver, but you know that way back in the day when you guys entered, or when your dad or mom were here in the U.S., one of their employers tried to help them. Oftentimes, this means that they filed for a labor certification either prior to that 1998 deadline or prior to the 2001 deadline. And in both circumstances, assuming you've met those eligibility requirements, you can use that to be grandfathered in to take advantage of 245I protections and file for adjustment of status in the United States.